Distinguished President, Turkish Academy of Sciences, distinguished deans, professors, esteemed guests, and valuable participants, good morning to all. Welcome to the second day of Turkish Academy of Sciences International Symposium on Artificial Intelligence, Intelligence Law, and Digitalization in Law. We trust you had a pleasant evening and are ready for another day of insightful discussions. Please note that all the presentation today will be conducted in English. For your convenience, simultaneous translation devices are available. If you require one, please see our staff at the registration desk. Now we will start with we will present a trailer about Turkish Academy of Sciences, and we can see the video now. Tanıtım filmini izlemek için açabiliriz.
Turkish Academy of Sciences, TÜBA, is an autonomous apex body for the development and promotion of sciences in Turkey. The origins of the academy go back to Encümenidanis, Society of Scholars, which was founded in 1851 and known as the first Turkish science academy in the modern sense. TÜBA is the single national academy in Turkey, and it comprises all fields of sciences which are grouped under three categories, namely A. Basic and Engineering Sciences, B. Health and Life Sciences, and C. Social Sciences and Humanities. TÜBA contributes to the promotion of sciences through its working groups, grants and awards, scientific reports and collaboration with sister academies in the world. TÜBA has awards programs addressed to both Turkish, national and non-Turkish international scientists. TÜBA awards are given to the awardees with the ceremony held under the auspices of the President of Turkey. TÜBA Academy Prizes were launched in appreciation and encouragement of eminent scientists in 2015 and open to all scientists in the world. TÜBA Academy Prizes are given to those scientists with original, leading and path-breaking works in their fields. Awards for outstanding young scientists, TÜBA Gebib, were launched in 2001, and this award program is one of the first of its kind in the world. The objective of TÜBA Gebib is to foster young, outstanding scientists who are at the stage of establishing their own research programs and networks in Turkey. TÜBA supports these scientists for a period of 3 years and helps them set up their own research groups at a stage when they are in need for incentives. Awards for Best Books, TÜBA TESEP, were launched in 2008 in order to encourage the writing and publication of qualified Turkish scientific works. The Academy working groups are engaged in various scientific events and publications in important and current issues. The project for Dictionary of the Scientific Terms in Turkish is being carried out in 4 main areas of social sciences, natural sciences, health sciences, and engineering sciences. The project for Turkish and Islamic science classics is aimed to make accessible the 100 classical historical works for the present and future generations. TÜBA has undertaken to complete and publish Andreas Tietze's famous work on the historical and etymological dictionary of Turkish, and so far published the first 4 volumes. It is planned to have the entire work by Tietze, the late Turkologist and TÜBA member, by the end of 2018. TÜBA cooperates with sister academies and inter-academy organizations in the world. TÜBA is the member of 12 inter-academy organizations and has bilateral cooperation agreements with over 30 academies. Rabi Madrasa, located in the Süleymaniye Külliye in Istanbul, hosts the national and international activities of TÜBA. As Turkey's national academy and being a member of the world scientific community, TÜBA will continue to remain in the service of science and general public by upholding the principles of scientific excellence and science ethics.
Thank you. Before starting, I would like to invite Professor Muzaffer Şeker to give his opening speech for today.
Dear distinguished guests, dear young scientists, and ladies and gentlemen, good morning to all. In spring already completed, but still there is time for summer term. Let's see. I mean, in Kayseri, we are, yesterday there was a good rain, and today is shiny day. I hope you enjoy in Kayseri Erciyes University hospitality during this 2 days. As already mentioned yesterday in opening ceremony, TÜBA 2020 February organized this workshop at Boğaziçi University. And the title was Information Technology and Communication, the Internet and Social Effects, and discussed on security of the state and also individual personality. Of course, this topic has been reported as a book in the TÜBA press under the publication already can be seen as an open source from our internet page. Despite the TÜBA's early warnings, some problems were not addressed in time. As a result, digital trees have grown. Now, new laws must go beyond technical issues and also focus on social safety, security, and ethics, and also public needs requirements. Today, we are not here only to talk about technology. We will also reflect on law, ethics, social values, and human dignity. Because artificial intelligence is not only a topic for engineers, it is shared issues for lawyers, thinkers, public leaders, and all of society covered our life. As artificial intelligence becomes part of decision making, the line between human will and machine control becomes unclear. There is a fusion between us. This creates big questions for law and technology. Who is responsible when an artificial intelligence makes a decision? What is the legal and moral results when it affects human life? These are not only technical questions, but also social and ethical ones. Like all technological developments, artificial intelligence is powerful and valuable, of course, but this power must be used with care. If we only use it for speed, profit, and competition, the risk losing respect human dignity. Technology should grow with ethics, and ethics must put people first. Humanity should be considered earlier. Today, many global problems are linked to the loss of community feelings. Personalized digital wars are breaking our shared reality. Screening friendships replace neighborhood ties. Data replaces solidarity, and our ability to act together is failing. In this situation, law must not only regulate but also protect and balance within the society. Artificial intelligence is not only a social matter, but also a strategic one for states and trade companies and whole society. Privacy, personal data abuse, and cyber threats are now both national and global concern. In the digital age, data is the most fragile part of freedom. Without protecting data, we can protect neither safety nor liberty. Laws like the European Union Artificial Intelligence Act show us that artificial intelligence needs legal control, not just technical standards. It is important for Turkey to be part of this global legal movements, to build strong national laws that also match global values. This symposium will help us reach that goal through academic knowledge, legal insight, and social awareness. I believe the ideas shared here today will help shape not only today, but also for tomorrow's. I thank all speakers, moderators, scholars, and initiatives which support this event, and especially RGS University for hosting it. I wish you all productive and inspiring symposium. Sincerely, thank you for your patience and attention.
Thank you, Professor. Now we will proceed with our international sessions. We will now begin our first international session titled Artificial Intelligence Systems, Intellectual Property and Insurance Law Issues. Since all the professors are on the stage, I will just announce them. We will now, to chair this session, I would like to announce Professor Umut TÜRKSEN from Coventry University, United Kingdom. For his presentation titled Artificial Intelligence Systems as Legal Persons, I would like to announce Professor Michael MARTINEK from Saarland University, Germany. Next, for his presentation on artificial intelligence and insurance, I would like to announce Professor Helmut HEISS from Zurich University, Switzerland. And for his presentation titled The Digitalization of European Civil Procedure, I would like to announce Professor Jan von Hein from Albert Ludwig University of Freiburg, Germany. Dear Chair. Yeah.
Thank you, Alperen. So I'll be chairing this session and I'll keep an eye on the time. My one request after all the presentations are finished, we will have a question and answer. So if you could keep your questions succinct rather than making a long statement, just that would help us, to answer those questions as well. So that would be my request. So I'll invite Professor MARTINEK first for his presentation. Please welcome him with warm welcome.
Put that away. Good morning, everybody. Good morning, dear colleagues. Good morning, distinguished guests. Thank you for the introductory remarks, Umut. I am very glad and happy to be with you here today and to have the honor to, in a way, give the introductory first speech on this second day of our conference. As you already have heard, the topic and title of my speech is Artificial Intelligence Systems as Legal Entities. And there is a subtitle which you do not find in the programs, and that runs Stillbirth or premature birth of the electronic person. Now, dear listeners, I will not commence without uttering a word of gratitude. I am very happy to be here again at this university, where I've been some 15 years ago for the first time. And so I am, in a way, an old friend of the university, the more so since I know, for example, Professor Murat Doğan, and also Professor Sinan Okur is a distinguished friend, if I may say so, because he studied in Saarbrücken, Germany, where I stem from, and was my doctoral candidate, in fact. And I am, of course, very proud and happy to see him here again now and to observe his career. As you all, or most of you know, for a professor, it is a wonderful experience to see the disciples flourishing and thriving in a way. Now let us start with the topic. And as you have already been here, most of you at least, yesterday, you have heard a lot about the new AI regulation on the development, placing on the market and use of artificial intelligence, which came into force on the 2nd August 2024. So I do not need to describe the content and the task of this regulation again. Should we not surprised that the AI regulation is silent on perhaps one of the most important and currently much discussed legal policy issues in the international legal discourse on AI, namely, do we need the introduction of an electronic person or e-person in our legal systems, analogous to a legal or juridical person, in order to better deal with the problems of liability for damage caused by highly complex AI systems? Although the discussion is fading away already in some countries like Germany, it is just very turbulent, if I may say so, in many other countries, for example, the South American and some of the Asian countries. Indeed, the AI regulation deliberately, specifically, and generally omits liability issues from its regulatory scope. A special directive is being prepared for AI liability. However, the introduction of an e-person would not only affect liability issues, but also the regulatory concerns of the new AI regulation. The question of the meaningfulness, usefulness, or even necessity of an e-person has, as a quick research on the internet reveals, triggered a tsunami of legal and paralegal writings with headlines such as "Artificial Intelligence as a Legal Personality." The robot becomes a human being. A new species is born. Or the nightmare of legal personality for AI systems. For more than 10 years, the question of whether AI systems should be treated as digital e-persons with legal capacity has been debated internationally, primarily, but not only by lawyers and politicians. What is the situation now? Can it be explained that the AI regulation says nothing on this topic? Now, dear colleagues, friends, listeners, as lawyers, we always want to know exactly what we are talking about. And that's why I need to start by reminding you of some technical facts about AI and the fourth industrial revolution before we move on then to the question I mentioned, true to the principle that the fact finder is the decision maker. According to the definition in Article 3 of number 1 of the AI regulation on AI systems, an AI system is a machine-based system that is designed to operate with varying levels of autonomy and that may exhibit adaptiveness after development, and that, for explicit or implicit objectives, infers from the output it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. Less bumpy and perhaps easier to understand than the official EU officialese, an AI system can be described simply as a software-based system or a system embedded in hardware devices that exhibits intelligent simulating behavior by, among other things, collecting and processing data, analyzing and interpreting its environments, and taking action with a certain degree of autonomy to achieve specific goals. An AI system is autonomous if it functions by interpreting certain inputs and using a series of predetermined commands without being limited to such commands, whereby the behavior of the system is restricted by the goal given to it and other relevant specifications of its developer, or is geared towards achieving the goal. AI therefore refers to systems that exhibit intelligent behavior by analyzing their environment and, with a certain degree of autonomy, taking action to achieving certain goals. Can be purely software-based and operate in the virtual world, for example, voice assistants, image analysis software, search engines, speech and facial recognition systems, automatic diagnosis procedures in medicine, or stock market analysis, and so on. But it can also be embedded in hardware devices, advanced robots, for example, autonomous vehicles, drones, or Internet of Things applications. AI systems attempt to emulate the cognitive abilities of humans using algorithms. Put simply, algorithms are mathematical instructions, that is to say, control commands that ensure that a data input is converted into a data output. The instructions can be designed in such a way that the algorithm, on the basis of clearly specified action steps, searches for and analyzes patterns and correlations in a database in order to achieve a predefined goal. Now, this form of AI, which operates within the limits set by the programming, is referred to as weak AI. These are closed and mostly supporting systems, digital assistance systems as the ones I mentioned. This, and only this, is the area of Industry 4.0 in which we currently live. This is to be distinguished from the so-called strong AI, which is also initiated by a program command, but then develops independently after a machine learning and training phase. By using artificial neural networks, strong AI can acquire new cognitive abilities and initiate its own causal processes for which neither the goal nor certain alternative solutions can be predetermined. For example, available data resources can be searched for new findings, and the original algorithms can be further modified independently on this basis. The decisions made no longer appear to be abstractly predetermined products of clear programming, but rather the result of a truly autonomous process. Strong AI is therefore characterized by the fact that it leaves the initial determinism behind and overcomes it. This is no longer the domain of Industry 4.0, but will most likely become the domain of the fifth industrial revolution. According to most expert assessments, such a strong, human-like AI will exist in the foreseeable future, at least in the next few decades. However, the reality at present, and probably also in the near future, is still characterized by a weak AI with enormously accelerated automation of processes, with supportive and limited intelligent behavior. Don't be confused by visionary announcements that already suggest the emergence of precursors to strong AI. A few months ago, news went around the world that a Chinese metaverse company, a reputable video game and application developer, NetDragon Websoft, apologies for the inappropriate product placement, had appointed an AI-driven virtual humanoid robot as its CEO, a certain Miss Tang Yu, supposedly responsible for overseeing the company and serving as a real-time data hub and analytics tool to support rational decision-making and enable a more effective risk management system. If you study the news carefully, it becomes clear that Ms. Tang Yu still belongs to the fourth industrial revolution, as her artificial intelligence is only weak. Ms. Tang Yu is not yet capable of efficient human-machine collaboration or even neuronal networking, autonomous recognition and definition of tasks, and autonomous development of creative solutions to problems, as will be characterized of the strong AI in the future. Now, ladies and gentlemen, the existence of weak AI and the prospect of future strong AI in Industry 5.0 has triggered a growing concern, a growing sense of concern among lawyers and politicians, legal scholars and legislators, and sparked a heated discourse on the question of whether it will not become difficult to clearly assign and delimit responsibilities and accountability in the event of wrong decisions and malfunctions of AI systems, and whether it is not a need to adapt legal systems to the new developments. In this context, particular consideration is being given to granting AI systems their own legal personality, and thus the idea of an electronic person or e-person was born. In already 2017, almost a decade ago, in a resolution, the European Parliament proposed an electronic personality, in brackets e-person, for intelligent robots and autonomous systems. That is to say, a legal entity that is to be endowed with its own rights and obligations as an independent actor. That is to say, a new legal entity that can be held liable and can even be held criminally liable and subject to tax. Of course, this idea was not first formulated by the European Parliament, but goes back to futuristic writings of the first half of last century. In this 2017 resolution, the European Parliament explicitly called on the European Commission to create, I quote, a specific legal status for robots in the long run, so that at least the most sophisticated autonomous robots could be established as having the status of electronic persons, responsible for making good any damage they may cause, and possibly applying electronic personality to cases where robots make autonomous decisions or otherwise interact with third parties independently. In our legal system, or in our legal systems worldwide, the legal persons, legal entities, are actors who are recognized de jure and ex lege as having the capacity to bear rights and obligations, so-called legal capacity. Under current law, these are both natural persons, born and living persons, and legal entities. That is to say, associations of persons and assets in permanently established, purpose-bound organizations, such as corporations or foundations. Our legal systems worldwide do not recognize any legal persons other than the expressly selected and mostly registered legal persons that fulfill the prescribed legal requirements. These may also include, by the way, as in Canada, New Zealand, India, or Ecuador, ecosystems such as rivers, lakes or dams, temples or monuments. Today, there is hardly any doubt that this characterization is based on a legal political will and a legislative decision. It is not mandatory, not God-given, not an a priori ontological phenomenon. Certainly, originally in the 19th century, the concept of legal personality or legal subjectivity and capacity was partly linked to the nature of man and mystically exaggerated. However, as a result of numerous writings on legal philosophy and civil law theory, the view quickly prevailed, in Germany primarily under the influence of von Savigny's theory of fiction, that legal persons should be seen as purely functional and purposeful. Depending on their normative form, they embody legal aspects of the allocation of rights and duties, and as such are not pre-legally determined. Consequently, it was soon deemed permissible for legal entities to no longer be represented exclusively by natural persons. Organizations and even assets without a personal substrate, like foundations, could also be assigned rights and obligations, even if they have neither will, consciousness, nor emotionality without managing and representing people. On the basis of this prevailing functional approach, according to which the creation of legal entities is owed to an act of attribution under domestic law, the introduction of a new legal entity in the form of an e-person can certainly be regarded as feasible, in the sense of legally permissible and practicable. There are no a limine obstacles. The e-person could be introduced by the legislator at any time. Feasibility and permissibility are not an issue. All that is required is a decision by the legislator, which would have to be followed by a refinement of the doctrinal organization. Ethical considerations or even doubts can be marginalized by the functional approach. There is no reason to fear that granting legal personality to AI machines would mean equating them with humans, and in particular granting them the same rights that we enjoy as natural persons. Electronic personality would not be a threatening expression of a new kind of personal subjectivity competing with human subjectivity, but rather an additional artificial form of legal personality based on simple functional considerations and decisions. Of course, the e-person would raise many questions. The legal consequences that would result from the introduction of an e-person as an independent legal entity would certainly affect significant parts of the entire legal system. However, it would certainly be feasible. It also appears to be a very complex task, for example, to systematically identify the normative conditions under which it might be appropriate to confer a fictitious legal personality on a certain type of AI application, similar to what is currently the case for companies. By the way, it immediately comes to a lawyer's mind that granting legal personality is not the only way to achieve such effects. It is, nevertheless, a feasible way. However, this raises the crucial question: is it a necessary way? You see, the protagonists of electronic personalities point to the alleged need to close an otherwise disastrous gap in responsibility and liability in the current legal systems, and in the event of technical failure or technical systems that have been placed on the market incorrectly, a so-called responsibility gap. In fact, the introduction of a legal person in the form of an e-person would only be necessary and justifiable if the relevant areas of civil law, but also criminal law and public law, currently lacked legal subjects of attribution as well as responsible and liable actors. In reality, however, there is no evidence that any gaps in contractual responsibility and liability can be identified as a result of the development and use of weak AI systems. This concerns the particularly important area of the conclusion of contracts by automated and semi-autonomous systems. Of course, contractual or quasi-contractual liability requires a legal qualified relationship between the parties before any damage occurs. But even in non-contractual liability law, namely tort law and product liability law, no worrying legal loopholes can be identified in relation to AI systems that could not be easily compensated for by innovations inherent in the system. To summarize, given the existing liability rules today, I do not want to go into details, it is always possible to identify a natural or legal person who can be held liable for damages caused by the use of the weak AI system. In this sense, the liability framework may be suboptimal because it leads to costly and complex litigation, but it excludes the existence of a serious responsibility gap. It is not evident. For existing AI applications, recourse to traditional legal instruments is indeed available and practicable. The idea is as old as it is simple. Liability is imposed on whoever is in control of a particular risk and is liable to manage it successfully. Our conclusion is therefore obvious. The need to implant an e-person in the civil law systems at present cannot be recognized. All the problems that currently arise can be solved within the existing legal systems. Even the most complex and non-transparent AI systems of Industry 4.0 do not achieve such a degree of autonomy that a link to human behavior would no longer be possible. The resolution of the European Parliament of the 20th of October 2020 with recommendations to the Commission on a civil liability regime is also based on these considerations. The same European Parliament which in 2017 resolution had promoted the idea of recognizing AI systems as having legal personality explicitly departed from its previous position 3 years later and now states that all physical or virtual activities, devices or processes driven by AI systems can technically be the direct or indirect cause of personal injury or damage or to property, but are almost always the result of someone designing, operating, or acting on the system. This backtrack now emphasizes that it is not necessary to give AI systems legal personality. Now, it is therefore no coincidence and no omission that the new AI regulation, which came into force on the 2nd of August 2024, does not mention the e-person. The EU legislator has apparently consciously abandoned this idea. Instead, the Commission has presented and started to implement a coordinated plan to develop measures in the member states and at EU level. In particular, it published a proposal for a directive on the AI liability and on the same day a proposal for a directive to modernize the almost 40-year-old Product Liability Directive.
Professor MARTINEK, you have half a minute left for your time.
Thank you for granting me, as you mentioned, 5 minutes left. In Germany, by the way, the German Jurists Conference in 2022 dealt with the subject, and the majority of the experts in fact came to the unanimous result: the introduction of an e-person offers no advantage over the creation of strict liability or liability replacing insurance. In contrast, my highly esteemed successor to the Saarbrücken chair, Professor Dimitrios Linardatos, who is with us today and will be a speaker later on, was one of the few dissenting voices in his habilitation thesis to speak out decidedly in favor of the creation of an artificial legal entity for AI systems. Now, dear colleagues, dear listeners, when preparing this presentation, it is not a difficult presentation because I do not throw any pictures at the wall. I rely on the power of words and therefore deliver just an ordinary speech like in the old days. But when I prepared this speech, it was not difficult for me to anticipate your objections to my considerations. Because if we recall the distinction between weak and strong AI, then we perhaps cannot rule out the possibility that the current widespread rejection of an e-person in science and politics may be limited to weak AI systems, and that the foreseeable emergence of strong AI in the fifth industrial revolution will put the introduction to the electronic person as a patent solution back on the agenda, you see. Perhaps it is too early to lament the idea of the e-person as a veritable stillborn in the ongoing age of weak AI, because this idea would have a bright future in the coming decades when strong AI systems achieve a significantly higher degree of legal decision-making autonomy and break away from the developer and operator and take over the lead. The e-person may prove to be a premature birth that would have seen the light of day weakly, but could soon gain strength and in future may well be able to make a significant contribution to a central legal institution for dealing with AI-related liability problems. In any case, it seems too early for a necrology on the e-person who may rest in peace. We may hear about it again. Thank you for your attention.
Thank you very much, Professor Martinek. Yeah, someone will help you. While we wait for the presentation slides to be set up for Professor HEISS, think about your questions, if you may. I'm more than happy to translate, write them down. That sometimes helps. But while we wait for that, how many people know what's the liability of ChatGPT if you use it and you have a loss or an injury as a result? How much can you sue ChatGPT for? Does anyone know? Obviously, ChatGPT doesn't have yet legal personality, but the company does. So how much can we sue ChatGPT for? Let's have some guesses. Alison. Now, the user and terms and conditions state how much the company would be liable for if they cause a damage or an injury. Yeah. Yeah. How much do you think they are prepared to pay?
Probably not a lot.
For example?
Thousands.
Thousands. Okay. Anyone else to have a guess? Yes. Okay, Dimitris says no liability whatsoever. Any other guesses in terms of the amount of liability? Yes, Alperen?
There was a suit case in the US, I guess. They were charging $100 million for paintings.
Yeah, that's the claim, but when you, as a user, use the ChatGPT, you agree to the terms and conditions, And the terms and conditions states the company is liable for $100 US. That's it. Okay. No further review, but you can see how companies avoid. Yeah.
Hangi hukuk bağlamında soruyorsunuz hocam? Türk hukuku bağlamında mı?
Türk hukuku bağlamında değil, Amerika. Çünkü
ama Türkiye'de sonuç itibariyle
the company is registered in California, so the Californian law will apply.
Fark etmez. Burada hizmet yürüttüğü için ürün güvenliği sorumluluğu hükümlerine göre sorumlu olur burada.
Yeah, the assets of the company of course is in California, so it's a very complex issue to bring a claim. Anyway, no further ado, Professor HEISS, the floor is yours, and I'll keep the time on your presentation. Thank you.
Well, thank you very much. Thank you for the organizers of this conference for inviting me, having me here, also for the second time. It's been about 10 years ago that I had the pleasure of being here, and I'm very happy for this return. My speech will be on artificial intelligence, the program says, and insurance. That raises many, many different subjects, but I chose the one of liability insurance. You have heard my dear colleague MARTINEK speak about liability issues, liability gaps, but if we want there to be liability and we want liability to be effective, then this liability must be insured, because the one thing you need is not a person to be liable, like an e-person, but you must make sure that this person has money. If the person liable doesn't have money, liability will not help you in any way. So this is why I was taking up this subject, and my lecture will deal with a very short overview on the EU legislation on AI. You have heard a lot about that. I don't need to say much about it. And then insurance-related issues. First of all, I would like to mention insurance as an invisible legislator. Insurance always influences the regulation and the liability rules on everything, including AI. I would like to address the issue whether AI risks tend to be uninsurable and whether we need alternative compensation schemes, alternatives to insurance, liability insurance. I will address also the question, do we need insurance for what I call pure immaterial loss, loss of pain and suffering, not a physical loss, an injury, or a loss of property, but just pain and suffering. And also, do we need compulsory liability insurance in order to make sure that a liability will always be accompanied by deep pockets, a liability insurer being able to pay for the claims. Now, I've listed again the regulations. I will be brief. The EU Artificial Intelligence Act, a regulation, a horizontal regulation covering all types of artificial intelligence systems, differentiates between unacceptable risks, they are forbidden to be used, I don't need to deal with them, high AI risk systems which are regulated, very important precautions must be taken, limited risks where the operator must only be transparent, telling the users that they are dealing with AI rather than with human beings, and minimal risks which remain unregulated. So we are dealing with regulated high-risk AI systems, and this regulation may cause liability, of course, if you violate the regulations. What is more important from the perspective of liability is the new EU Product Liability Directive of 2024, which now dictates that software and systems of artificial intelligence are products, and a strict liability may result from any defect of such products. One of the defects may be that they do not comply with the Cybersecurity Act, another regulation of the European Union. And finally, there was a proposal for an AI liability directive, which was not really supposed to deal with liability, but rather with side issues of liability, but this has been withdrawn lately by 11 of February 2025. Now, what does all this mean for insurance? First of all, the liability directive on product liability hardly ever mentions insurance.
It doesn't deal with insurance. In spite of some pleas in the political community to install a compulsory insurance regime, the directive remains rather silent on issues of insurance. However, they do mention that the Commission has to evaluate the new directive in 2013 and 2030, and within this evaluation they should give information on whether product liability insurance is available in the market. And this goes to show that a legislator will always evaluate the degree of liability depending on whether the liability can be transferred to the insurance market on acceptable premium rates. And if this is not the case, there's a tough choice. Either you forbid the activity as too dangerous because it's not insurable, or you accept the risk and look for other compensation systems. So in a way, the availability of insurance is like an invisible hand dictating what the legislator will do in terms of regulating liability. This raises the issue of whether AI risks may be uninsurable. I don't think this is true in general. I think the insurance industry will easily cope with those risks. But it is very often said that artificial intelligence may cause systemic risks. We'll talk about financial issues in the afternoon, and some have prognosis that eventually financial systems may just break down collectively. And if this is the case, then of course no liability insurer will cover the risks resulting from such a systemic failure of an AI system. And we have seen software failing and causing losses around the globe, and this of course is not covered by one insurer, also not by a co-insurance arrangement. In such cases, indeed, we would need alternative compensation schemes such as pooling systems, which we have in nuclear energy liability or in terrorism cases, where the individual risks are simply too big to be covered by regular insurance. You can also bring the risk into the capital market by linking insurance to a security and then get investors to cover the risk upfront by investing the sums that are needed for covering damages. Or you combine insurance solutions with public subsidies. You create public-private partnerships, again an alternative mean of covering such risks. I think there are certain AI risks that are affected by these considerations, but in general I would say AI risks are insurable in a traditional sense. What I do want to highlight, however, is that we may see a shift in the types of losses arising. We may think of a medical AI system, and we may think of physical loss suffered by patients when they undergo surgery done by AI. This is a rather old-fashioned case from the perspective of liability insurance, because liability insurance typically covers personal injury cases or damage to property cases. But we will hear a lecture today on the selection of employees, a decision-making by AI to select this person rather than the other person, and there may be a bias and one person may be discriminated against. Now, the loss occurring out of such a wrong decision is a pure economic loss. There is no personal injury, there is no damage to property, it's a purely economic loss. And we also see in the list, in the Annex 1 to the AI Act, on high-risk AI systems, many of them cause rather damage to human rights, to personality rights in the private law area. They cause discrimination that feels bad, that may give pain and suffering, and we will have indemnifications based on pain and suffering. They stem from violation of a personality right, but violation of personality right in general, and at least in the German industry, is not covered by liability insurance. So what we end up is, from an insurance perspective, with pure immaterial loss not covered. But those who will be held liable will need insurance. And I think in this way we must heavily expand the scope of cover of liability insurance as compared to how we know liability insurance today. Finally, and this is my strongest point, the question, do we need compulsory AI liability insurance? One thing is clear, national law is not suitable to solving the EU problem of this question. We have had one case decided by the European Court of Justice that concerned a breast implant, a product, a breast implant that was produced in France, but used for a woman living in Germany. And when the personal injury occurred, this woman was suing the French producer, and the French producers, no, actually it was suing the insurer, the liability insurer of the French producer, because in France there is a compulsory liability insurance on such products. And the insurer refused to pay, saying that I only cover damages occurring in France. And the question came up whether the law of the European Union demanded the national legislator, in this case France, to broaden the scope of cover to other EU nationals like Germans or Greek or Spanish or Finns. And the answer was no. There is no rule in EU law that would require that a national legislator, when introducing a compulsory liability insurance regime, would be forced to include in the scope of protection victims from other member states. So a national solution is still valid under EU law. And that means we must create a European solution if we want compulsory insurance. But compulsory insurance is not mentioned in the Product Liability Directive, even though many actors have actually asked for the introduction of such a compulsory regimes. The AI Act does contain one compulsory insurance, which is the insurance of so-called notified bodies. Notified bodies are those state institutions that control whether high-risk AI systems comply with the standards of the AI Act. Of course, there's a risk of liability, because if you certify that a certain system is in conformity with the AI Act, and later on you find out it was not, then all the people damaged may actually, all the victims may sue you for liability. So the AI Act says those notified bodies must take out appropriate insurance. Now, it's very interesting. It shows the concern of the European legislator, but the European legislator does not really deal with its own concern. It says appropriate insurance. That gives you some guidance on what would be sufficient and what else would be insufficient insurance, but it doesn't give you any detail. And the solutions that will be taken by national legislator will vary to a large extent, and the limits that must be observed will vary. You will have 1 million here, 10 million there, 100,000 in another place, and nobody will really know what is appropriate. So I wonder whether we need new ways in compulsory insurance on the union level of legislation. The first question to be answered is, do we need compulsory liability insurance for AI as such? And I want to be very short to make up for some time. My answer would be no. We do not need a horizontal duty to take out insurance for any type of AI. If any, we need it for high-risk AI systems. And I think even there we need sectorial solutions. Some AI risks rather affect my dignity and will cause pain and suffering, and you will be able to estimate what the sums available to the victims will be and whether you will need insurance for this, or whether those running those systems will be perfectly able to bear their liability themselves. In other areas like medical devices, probably you need liability insurance because they may cause huge damage, and in any event you must really make sure that systemic risks are covered in one way or the other, not just traditional liability insurance but also alternative compensation schemes. But what we need even more, and this is not only a concern of artificial intelligence, we need to get off those naked duties. These duties to take out appropriate insurance with no detail given. What happens with such an insurance if the policyholder and tortfeasor did not pay the premium? Can the liability insurer tell the victim, sorry, the tortfeasor who has done damage to you didn't pay the premium, I'm not liable? Or it didn't take care of precautionary measures it was obliged to take care of, so I'm not liable? What about other cases where the liability insurance freed from liability? Which amount of liability must be covered? Can it be 1 million here, 3 million there, 100,000 in the third member state? That cannot be the case. So my idea would be to clearly determine those individual sectors of AI where we first of all need a compulsory insurance scheme. And once we have detected them and we have created artificial intelligence, then we need a horizontal regulation on details of any compulsory liability insurance regime, not just the one for medical devices or for face recognition systems, but for any, including motor liability, including other. We have compulsory liability insurance schemes in the marine sector, in the airway sector, and so on. And they lack, other than motor vehicle, they all lack details. So we need a horizontal regulation on compulsory insurance, and I think artificial intelligence could actually be the occasion on which we will take up this issue. Now I'm aware that this was a very, very short, brief overview, but I'm also aware that you have many speakers and I should have been short, so I hope for your understanding. Thank you very much for listening to me.
Thank you, Professor HEISS, for keeping at the time. And now we have Professor Jan von Hein as our next speaker.
Yeah, distinguished members of the Academy, dear colleagues, ladies and gentlemen, thank you very much for the honorable invitation. Unlike the previous speakers, it's my first time here at this beautiful RGS University, and well, I'm now coming to my topic to make up for some time. I'm going to talk about the digitalization of European civil procedure. You see here the agenda of my talk. I will give first a short introduction to the subject, then an overview of the current state of digitalization, and then I come to the main part of my presentation, which will deal with the digitalization with regard to the taking of evidence and the conduct of proceedings, and I will then finish with conclusions and future perspectives. So, we have since 2023 the digitalization regulation, or as the full title of this regulation is the Regulation on the Digitalization of Judicial Cooperation and Access to Justice in Cross-Border Civil, Commercial and Criminal Matters, and amending certain acts in the field of judicial cooperation. The goal of this regulation is summarized in recital 3, which states that for the purposes of enhancing judicial cooperation and access to justice, legal acts of the Union providing for communication between competent authorities, including union bodies and agencies, and between competent authorities and natural and legal persons, e-persons not mentioned here, for conducting such communication through digital means. So this regulation aims at a rather comprehensive framework, but as the subtitle "and amending certain acts in the field of judicial cooperation" shows, this is not the only regulation in the EU which deals with aspects of digitalizing civil procedure. Already prior to the digitalization regulation, the EU evidence regulation and the EU service regulation had been reformed in 2020 in order to better take the possibilities of digitalization into account. And in the following, I will analyze the current state of the digitalization of EU civil procedure with a particular focus on the taking of evidence and the conduct of proceedings by digital means. Before 2023, we already had the reform of the service regulation that I've just mentioned. There are three main features of this large reform. First of all, the communication between the central authorities became electronic after that, so no more slow conventional postal services. The authorities shall communicate or must communicate by electronic means. There is also a provision of on the legal effects of electronic documents, so documents cannot be refused simply because service was effected by electronic means. And we also have special rules on electronic services, so we here have autonomous rules within the EU regulation. The EU regulation no longer refers merely to the domestic laws of the member states. In a parallel reform of the evidence regulation, provisions were introduced on the electronic transmissions of requests and communications, so also within the ambit of this regulation, the authorities are expected to communicate with each other by electronic means, a parallel provision on the legal effects of electronic documents, and specifically in this conference in innovation, the video conferencing for the taking of evidence was regulated in this regulation, but not for mere party hearings. In addition to this, oh, there's a cat here. In addition to this, we have scattered rules in other EU regulations, for instance, in Article 7 of the EU Payment Order Regulation, which also deals with electronic communication, and for instance, Article 15A of the EU Small Claims Regulation, which enumerates some methods for the cross-border payment of court fees, which has been a problem particularly in this regulation, which deals with small claims procedures, and you don't want that the payment becomes more complicated than the litigation in itself. The digitalization regulation aims at establishing a uniform legal framework for the communication both between the competent authorities and between natural or legal persons and the authorities, but as I've already said, the framework is not as uniform as it sounds, because there are also these other regulations which have to be taken into account. In addition, the digitalization regulation lays down rules on the use of video conferencing for purposes other than the taking of evidence. So when it comes to the taking of evidence, we still have the rules of the evidence regulation, which take precedence for this specific but very important area of law. We have provisions on electronic signatures and electronic seals, on legal effects of electronic documents, apart from the evidence and the service regulation, and a general provision on the electronic payment of fees. So, with regard to the first aspect, the use of electronic communication between competent authorities, the regulation aims at creating a secure, efficient and reliable decentralized IT system. Further details are spelled out in the e-Codex regulation, which had been passed roughly a year before in 2022. In order to improve the use of electronic communication between citizens and the competent authorities, a European electronic access point is established. So in the future, most communication shall be effected via this European electronic access point in the European Union. With regard to the use of video conferencing for purposes other than the taking of evidence, Article 5 of the Digitalization Regulation creates a new provision which deals with the participation in a hearing through video conferencing, which of course then throws up the question, what is a mere hearing and what is an interrogation, so a taking of evidence? I will come to this problem later. With regard to the application of electronic signatures and electronic seals, Article 7 of the Digitalization Regulation largely refers to the EIDIS regulation from 2014, which has also been recently amended in 2024 by the Regulation 118, which introduces the European Digital Identity Wallet, which creates a uniform method to identify yourself with regard to these European regulations. With regard to the legal effects of electronic documents, we have now an Article 8 of the Digitalization Regulation, which extends the recognition of electronic documents that we already had in Article 6 of the Service Regulation and Article 8 of the Evidence Regulation. This approach is extended beyond the scope of these two regulations. With regard to the electronic payment of fees, Article 9 of the Digitalization Regulation facilitates cross-border payments. Payments shall be made in the future also through the European Electronic Access Point. So this is not just a medium for communication, but also can be used to effect payments. Before that, we had the Article 15A of the EU Small Claims Regulation, which rather referred to conventional methods of bank transfers or credit card payments. In addition to this, the Digitalization Regulation makes various amendments to the existing EU regulations on civil procedure. Particularly a new Article 19A is introduced or is inserted into the Service Regulation, which deals with the electronic service through the European Electronic Access Point. It should be noted that this method of service presupposes that the addressee has given prior express consent to the use of that electronic means for serving documents in the course of legal proceedings concerned. So it's not mandatory, you have to give your prior express consent at first. With regard to the EU Payment Order Regulation, a new Article 7, 5 and 6 is introduced on electronic communication, which substitutes the older version, and in the EU Small Claims Regulation there is also a new Article 15A on electronic payment of court fees, which makes clear or which clarifies that now the European Electronic Access Point can be used with regard to this regulation as well. I now come to the main part, the digitalization of the taking of evidence and the conduct of proceedings. In the European Union, we have the reformed or the recast European Evidence Regulation of 2020, whereas in relation to third states, we still have the Hague Evidence Convention, which is, for instance, enforced between Turkey and Germany. The evidence regulation is, however, in many aspects modeled upon the evidence convention, so it's possible to a certain extent to draw comparative lessons from the regulation to the convention and also vice versa, although one has to keep in mind that the regulation as an act of EU law is interpreted autonomously by the European Court of Justice, and the Hague Convention also is subject to its autonomous interpretation. Neither in the Evidence Convention nor in the Evidence Regulation do we have a definition what evidence actually is. We have some guidance in Article 3 of the Evidence Convention, and we also have some further guidance in the Practical Handbook. The main problem or the main difference, the main divergence between the two legal instruments is that the Evidence Convention also covers the performance of other judicial acts, for instance, attempts at conciliation between the parties, settlement hearings, or just a simple video hearing, which is not an interrogation in the technical sense of taking evidence. But those judicial acts, those other judicial acts are not covered by the evidence regulation. Here, the scope of the regulation is limited to measures that aim at obtaining information that serves the judicial establishment of truth or conviction in the proceedings, so evidence in the narrow sense of the word. Nevertheless, the reform of 2020 had already brought some innovations. The electronic transmission of documents via a decentralized IT system was established as a rule. There was also a legal definition of a decentralized IT system introduced. Of course, this also refers to the e-codex system, which was established in 2022, although this article is not yet applicable due to the need to establish the necessary legal and technical prerequisites, the interconnectedness in all the member states. There are some exceptions from the electronic transmission of requests and documents in Article 7, paragraph 4. The first case is when there is a disruption of the decentralized IT system. In this case, of course, you can also use other means of communication. Then there are cases in which the transmission via the IT system is not possible due to the nature of the evidence. For instance, in a family matter, if you have a DNA sample, it's probably hard to digitalize it. Of course, you can digitalize the information, but the sample in itself would have to be transported by other means to the court that has ordered the evidence. And then there's a general clause for extraordinary circumstances, pandemics, war, and other things like that. The Evidence Convention contains no specific provision on electronic means of communication, but it's technologically neutral and does not prescribe the use of electronic means. This is a matter for the member states. With regard to the legal effects of electronic documents, already before the digitalization regulation, the evidence regulation introduced a specific provision. In principle, the question as to whether and how a court could use evidence obtained through mutual legal assistance is covered by the lex fori. However, Article 8 of the evidence regulation specifies that documents transmitted through the decentralized IT system, as defined in Article 7 evidence regulation, shall not be denied legal effect or considered inadmissible as evidence in the proceedings solely on the grounds that they are in electronic form. The consequences are as follows. The receiving state may not reject an electronic request solely for this formal reason. The requesting state, on the other hand, may not consider the request unresolved merely because of the electronic form. The further evaluation of the evidence then remains subject to the lex fori. In the Hague Evidence Convention, again, there is no specific provision on this matter because it's an older convention which does not deal specifically with aspects of digitalization, but the practical handbook clarifies that evidence also covers information stored in digital form. The point that is discussed most heatedly at the moment is the use of video conferencing in civil proceedings, and this is also the most important practical aspect. In the original version of the evidence regulation, which is rather old and was passed in the year 2001, we just had a simple Article 17, paragraph 4, sentence 3, which stated that the competent authorities should encourage the use of communication technologies, but it did not contain any specific provisions on that. Already then the question was discussed whether it is necessary to ask for legal assistance in a formal manner if the domestic court hears a witness located abroad via video conference while the court members remain in the home country. An internationally widespread view, especially in common law countries, says that there's no prior permission needed for such a video conference, and even in Germany some high courts, such as the German Federal Patent Court and also some lower courts during the COVID pandemic, followed this view. The prevailing opinion, however, was that the direct taking of evidence was already within the scope of the old Article 17 and is now within the scope of Article 19 and 20 of the current regulation. The German Federal Court of Justice has also confirmed this view with regard to video conferences in criminal procedural law. However, the Court of Justice of the European Union created some doubts with regard to this opinion because in the Pro-Rail case, which did not involve a video conference but sending an expert to the territory of another member state, said that with regard to the activity of a court expert in a foreign state, the compliance with the prescribed provisions on mutual legal provisions was not necessarily mandatory. And this again revived this discussion whether you need mandatorily, necessarily a permission for a video conference. The Commission's proposal of 2018 differentiated between two scenarios, whether the person making the statement voluntarily participated in the questioning or not. However, this was dropped, and now the explicit reference to Article 19 and Article 20 of the Evidence Regulation confirms that the regulators assumed that even a video hearing of a person giving the consent requires prior approval by the central authority of the state of residence. The requirements of Article 20 then are the follows. First of all, the provision only deals with the interrogation of a person as a witness party expert, but not with a mere hearing. The residence of the person in another member state is sufficient. It does not presuppose a habitual residence or a domicile in a foreign state. There's another cat here. Then the necessary technological means must be available, and the use of video conference technology must be appropriate in the given case. For instance, it may be inappropriate in certain family matters, such as the protection of vulnerable adults, where the judge needs to gain a personal impression of the adult concern. The problem that we have now is to distinguish Article 20 of the Evidence Regulation, so the interrogation in a technical sense of taking evidence, from Article 5 of the Digitalization Regulation, which covers a mere hearing. This is important because the requirements of Article 5 are lower. There is no prior approval from the other state needed. So in the conduct of proceedings for lawyers and for judges, it's very important to know whether you are in the stage of a formal interrogation, then you have to ask for a prior approval of the other state, or if it's a mere hearing for informational purposes, then you can proceed as you like. So this is very important, and the German Federal Ministry of Justice in September last year even sent a letter to all courts which stated that party hearings should generally fall within the scope of Article 5 Digitalization Regulation, so the government wants the courts to make a rather generous use of the new methods. We also have to take into account the case law of the Court of Justice of the European Union. Already in the Aguirre-Zaraga case, the Court of Justice stated that in custody matters, for instance, and in other family matters, courts should make use of modern technological means such as video conferences. That was then under the evidence regulation. This approach has been confirmed by the Brussels IIb regulation of 2019 and also by the German Federal Ministry of Justice in this letter to the courts. However, this may be more difficult in practice than it sounds on paper, because in certain family matters, for instance adult protection, which I've already mentioned, video hearings may not be appropriate under German domestic law. The Family Proceedings Act, even in its revised version, does not permit a video conference if a personal hearing is required by law, and this is the case for instance, with regard to the protection of vulnerable adults. Here you still have to gather, to gain a personal impression as a judge. So I then have some further comments which may be interested for the Turkish participants on the Hague Convention, but I skip these now for time reasons. Summing up, the EU as a supranational institution is able to implement a uniform framework for the digitalization of judicial cooperation and access to justice in cross-border civil and commercial matters. Nevertheless, there are still questions of overlap and distinguishing between various legal instruments, so the framework is not as uniform as it could be, particularly with regard to video conferences, where we have to draw the line between Article 20 of the Evidence Regulation and Article 5 of the Digitalization Regulation. In family matters, legal uncertainties with regard to the necessity of personal hearings and the relationship with domestic law remains. On the other hand, the Hague Evidence Convention, for instance in German-Turkish relations, does not prescribe the use of any technical means, but here we have to look at the practice of the member states, because there is no further supranational court or legislature dealing with these matters. So this is a very brief overview of the current state of digitalization in European civil procedure. I thank you for your attention. I hope that you found my talk more interesting than the cats, who seem not to be very interested in it. So thank you for your attention.
Thank you. Now, we are slightly over time, but we have time, and we have to make time for question and answers. So I will look at the audience first. I have a few questions, but I'm not going to use my time to pose those if there are questions from the audience. Yes, this young gentleman on the fourth row there with glasses, blue shirt. If you could introduce yourself, who you are first, that would be nice.
Hi everyone, I am Eren, recently graduated from law faculty and wishing to pursue my academic career on IT law. Actually, I was going to ask this question yesterday, but today this is discussed, so it's going to be okay for ask it. And I'm going to ask, by the way, thank you for everything, and I hope you're enjoying very much. We are certainly do. I am curious about e-personality, and I think it's going to be okay for dear Professor Michael about e-personality. Isn't the e-person another case of the wheel of legal personality? The wheel of legal personality, because legal personality have been using for malicious intentions a very long time. Considering corporates have limited power, and AI may have much more malicious uses. So how can we measure? How can some measurements are be taken, or there are some like discussions are going on? I'm just curious about it. Thank you.
Thank you. I think it's a question for Professor MARTINEK.
Thank you. I hope you can all hear me well. Yes, no doubt. Dear colleague, the idea of an e-personality is familiar with us from basically the law of corporations or company law in the wider sense. And this is where also the mostly discussed problems stem from, like the one you mentioned, the piercing of the corporate veil, which immediately raises the question, and I couldn't agree more, that could we not, so to speak, face the very same problems when we install an e-personality for artificial intelligence systems. Could very well be that this is the case, at least partly. But as you know from the law of corporations, in at least the long run, the judge-made case law, or even the legislator in the civil law countries, have well managed to cope with these problems and have found solutions. And so far, we should not refrain and abstain from the idea of an e-personality in the long run, if it is indeed not only possible, as it is the case, but indeed necessary to install such a new institute in our civil law systems. let me just shortly remind you, the gist of my paper was that it is easily feasible and possible to install an e-personality for AI systems, but it is presently not yet necessary, and the reason being that we are still dealing with a weak artificial intelligence where it is perfectly all right without finding any responsibility gaps to make useful the ordinary civil law instruments. But in the long run, namely as soon as strong AI comes up, only then the idea will certainly be worth considering.
Thank you very much.
Thank you. If you don't trust your English, you can ask your questions in Turkish. Sorularınızı Türkçe'de sorabilirsiniz.
Thanks. I'm Assistant Professor Dr. Hakan Koçak from Social Science University of Ankara. And I have one question to Professor Martinek and two short questions to Professor HEISS. And for the first question to Professor Martinek, in Turkey for recent years, AI is debated in terms of IP law, the ownership. And in recent years, for example, from Australian court case, there is an Australian court case on Dabus case, and this is so debated in Turkey. And if we accept AI legal personality, how we determine and the border of the ownership of AI? Because in, for example, today's European regulation, AI may be accepted as person and also product. And the other question to Professor HEISS is, in Turkey, most of the insurance policies is motor liability insurances, and more than 90% conflict is emerged from motor liability insurances. And nowadays, for example, autonomous cars is gradually evolving, and for the following years, maybe we will use AI-supported cars. And how we determine the, for example, fault or duty of care of the insured person in terms of insurance policy, because it's also affect the, for example, subrogation rights of insurance company to use to insured person or to the, for example, producer of car because of liability, production liability. And the second question is also in terms of insurance companies, because we also use benefit from the AI machines in terms of legal interpretation, not even though not exactly, but for example, if an insurance company would like to use AI system in terms of internal control, for example, how we determine and balance of the internal control duty of insurance company if insurance company use AI system, and also how affects the, for example, board of directors liability insurances if the company use AI system for internal control.
Thank you for those questions. Would you be happy, Professor Martinek, if I give the floor first to Professor HEISS, and then you answer your question?
Thank you very much. The first question concerns motor vehicle liability insurance, where we have an established system of victims' protections. And I want to mention that this system not only consists of a liability insurance regime, where the driver who is at fault will be covered by a liability insurance. And this, of course, is also beneficiary to the victim, because this victim can go directly against the liability insurer, and the liability insurer will always have money There's always deep pockets. This is, of course, beneficial, but it goes way beyond, because we have many cases where the driver of a car that was uninsured causes huge losses. We had such a case with a Lithuanian car that was hurting a baby child from the UK, and there is losses that goes into the millions, and you cannot bring back the health of this child, but at least you can give money for support. And if the car is uninsured, liability insurance doesn't help. So you have indemnification systems where basically the idea is that the overall community, the consortium of all the motor vehicle liability insurance will actually pay in total for those losses and cover them. And also when an insurance company will go insolvent, there is now regimes in place that will cover up for this insolvent insurer. And in cross-border cases, you have special regulations for such compensation schemes when a visiting car is hurting you in your home country, in your country of residence, and vice versa, rules that you will be indemnified when you visit a foreign country and you're being insured by a car that is licensed in this visited country. And why I'm mentioning this? I'm mentioning this because giving up on this system of holding the operator of a car liable and then passing the liability on to a liability insurer and all this huge developed system behind the liability insurers is not an easy thing to do and should be done with caution. But there is an argument for giving it up, which is exactly the one you mentioned. Under the current regime, a liability insurer will pay, and then the liability insurer will take recourse against those persons who are really liable, those who created the AI, which serviced the AI. And this is why we may want to more directly channel the liability with the person who will ultimately pay, which is the liability insurer of the operator of the AI system. And I think there is an argument in shifting the liability from the operator of the car to the producer of the car and the AI components and the liability insurer behind. But shifting this liability means giving up on the existing very, very developed system of victim protection in motor vehicle liability insurance. And I don't think this is a feasible way, at least not in a short term. This will take decades to replace. And the other question I cannot fully answer, I fear, but clearly artificial intelligence is very attractive to the insurance industry. It has already been mentioned that certain decisions taken by insurers, for instance, to grant life insurance cover to a certain person, but to reject another applicant for life insurance, may be discriminating. And if it is done by AI, such systems of AI are considered high-risk AI systems, and they must comply with the increased requirements of the AI Act. Now, I think when you say that directors and officers will delegate duties they have to comply with to artificial intelligence, and when artificial intelligence fails to perform properly, they will say, well, it was not my fault, it was the artificial intelligence. I think this problem, but I've not studied this problem deeply, but I think you can solve it the same way you do it with delegation of duties by directors and officers in general, also to human beings. They can delegate. They can say an investment decision I will delegate to some investment advisor. Other decisions I will delegate to an employee. But I will always have a residual liability in supervising this. And I think in this sense they will also have to supervise artificial intelligence systems. And if there is a lack of this supervision, I think they will not be able to just refer to the artificial intelligence system and deny liability. I think they will ultimately still be liable. But this is not something I've studied. This is something I'm sensing in a way, not
Thank you very much for your question, dear colleague, which, if I understood it rightly, centered around the issue, how can we identify the ownership or the proprietor of an IA system under the rules of an e-personality? And my answer is basically that this is no longer necessary once we have decided to actually insert the idea of a e-person into our civil law systems in the future. Look, presently under the ordinary civil law rules of liability, we have a multitude of different persons who could possibly be held liable in the case of a faulty behavior, wrong decision, causing damages of an AI system. To begin with, the developer, the manufacturer, which is possibly not the same person or company. Then, of course, the one who actually operates that, sets the AI system in motion, so to speak, the user, the beneficiary perhaps also, and then also, no doubt, the formal owner in the sense of the proprietor. So there is a multitude of persons which we can hold liable under the existing rules. In case that is no longer making sense and no longer feasible because we have a switch from weak AI to strong AI, and it is not anymore so easy, at least, to allocate personal responsibility to either of the persons. Then we have the e-person as such, as a legal entity of its own, having its own right and duties, no matter who the owner is, no matter who the manufacturer is. And as Professor HEISS rightfully pointed out, the situation is always the same, whether you are dealing with natural persons or with legal or juridical persons. The main thing is, are there any assets? Are there any assets to actually get the money to compensate for damages? And insofar, the insurance issue is no doubt a very important point. But in the first run, and in the first instance, it might perfectly in order to endow a legal personality called e-person with a certain asset, as it is at least traditionally the case with corporate companies. In the law of corporations, we have the idea of a minimum capital as a principle, to hereby have a certain security already. And only if the resources are exhausted, then insurance issue may come into play. And insofar, I think it is even a little bit of a Janus-faced situation. On the one hand, we have a multitude of possible persons can be held liable, but in case that it's no allocation of responsibility manageable anymore, then we must escape into an e-person, but then, of course, we must endow it with assets and insure this person properly. Let me just add one point, namely, we should, dear colleagues, abstain from the idea to always think of driverless vehicles and of autonomous driving as the number one example for AI systems. The promoters of the idea of e-personality do not actually think of, you know, insurance of all the new types of vehicles without a driver. as legal personalities. That would certainly not make sense. Imagine the sheer number would not be copable with. No, we are indeed concentrating on really highly complex systems where perhaps the damages are indeed even more serious, possibly, and in so far the issue concentrates on really complex industrial or service-related types of autonomous industry. The ordinary vehicles, even if driverless, can certainly remain subject to our ordinary insurance systems, even in the case of.
Thank you. We'll have a 10-minute break in a minute, but before we conclude, I want to just very short words. Today we've considered some very important philosophical and legal issues and questions, and what it boils down to is what the founders of artificial intelligence mentioned in 1955 is the meaningful human control, and that's something that we must never forget. And we need to look at, develop and use the technology with a great sense of responsibility. Neither we are any close to establishing what type of, or what level of autonomy and consciousness we need to be able to give any electronic system a personality. So we need to still work on these questions as scholars, whether we are computer scientists or legal scholars. So we'll continue the interesting discussion. And please use the break, the coffee break, to ask further questions to our speakers. Thank you. Another round of applause, please.